This is the image they tried to bury. A gavel slamming down in Geneva, Switzerland, inside the World Trade Organization's dispute settlement chamber, while a team of American trade lawyers sits in stunned silence, their briefcases still open, their legal arguments scattered across the table like debris after an explosion. As of 9:47 a.m. Central European Time this morning, Tuesday, March 4th, 2026, the World Trade Organization has issued an emergency interim ruling in favor of Canada and against the United States of America in one of the most consequential trade disputes in the history of the global economic order. For the first time in the modern era, the WTO has used its expedited dispute resolution mechanism to declare that a sitting American president's tariff regime is in systemic violation of binding international trade commitments. This is not a consultation. This is not a recommendation. This is a ruling with teeth. The timing is surgical. This ruling lands less than 2 weeks after the United States Supreme Court struck down the IEEPA tariffs on February 20th, 2026. In a devastating 6-3 decision. It lands 4 months before the mandatory CUSMA joint review on July 1st, 2026. And it lands at the exact moment when the Trump administration is scrambling to replace the voided IEEPA tariffs with a patchwork of Section 122 levies that expire in 150 days without congressional approval. We are talking about $35 billion in Canadian steel and aluminum exports hanging in the balance. We are talking about $412 billion in total bilateral goods trade under threat. We are talking about 14 million North American jobs tied to the trilateral trade framework. We are talking about $1.9 trillion in total North American commerce that moves through the arteries of the CUSMA agreement. We are talking about the credibility of the United States as a rule of law trading partner being shredded in real time on the world stage. The financial contagion from this ruling will reach every boardroom, every factory floor, every farm in the heartland before the week is out. In this special report, we are going to break down the legal mechanism behind this emergency WTO ruling. We are going to explain why Trump's legal team had no viable defense. We are going to reveal how the Supreme Court's IEEPA decision actually made this WTO defeat inevitable. And we are going to answer the question that is keeping trade lawyers up at night. Can the WTO actually force the most powerful nation on earth to reverse its tariffs? Or has America just declared war on the international trading system itself? Buckle up. The architecture of global commerce is cracking in real time. To understand why this ruling hit like a freight train this morning, we have to go back to March 2025, when Canada fired the first legal shot. On March 5th, 2025, the government of Canada formally requested WTO dispute settlement consultations with the United States, arguing that Trump's 25% tariffs on Canadian goods imposed under the International Emergency Economic Powers Act violated America's binding commitments under the 1994 General Agreement on Tariffs and Trade. 1 week later, on March 12th, Canada filed a second WTO complaint specifically targeting the 25% tariffs on steel and aluminum. According to Canada's legal filings, the United States had bound its tariff rates on these products at a maximum of 2.6% under GATT schedules. A jump to 25% was not a policy disagreement. It was a flagrant treaty violation. Here is what you need to understand about the legal plumbing. Under GATT Article I, the Most Favored Nation Clause, the United States is obligated to apply the same tariff rates to all WTO members unless a specific exemption applies. Under GATT Article II, the United States cannot impose tariffs above its bound rates without compensating affected trading partners. The bound rate on Canadian steel is 2.6%. Trump imposed 25%, then doubled it to 50% in June 2025. That is not a rounding error. That is a 19-fold increase over the legal ceiling. The United States tried to invoke the national security exception under GATT Article XXI, the same argument it used in 2018 when it first slapped steel tariffs on allies. But here is the catch. WTO dispute panels have already ruled 4 separate times against China, Norway, Switzerland, and Turkey that the 2018 steel tariffs did not meet the Article XXI threshold. The panels found the tariffs were not imposed during a time of war or genuine emergency in international relations. They were economic protectionism dressed up as national defense. The precedent was already set. The argument was already dead. The WTO panel assigned to Canada's case moved with unusual speed. Sources inside the WTO Secretariat say the panel was composed by January 2026, and preliminary arguments were heard in a closed session in February. The expedited timeline was driven by what the panel called the extraordinary and escalating nature of the trade measures, combined with the irreparable harm being inflicted on Canadian industries. Bae Bruska, president of the Canadian Labour Congress, stated 23,000 steel jobs and another 9,500 aluminum jobs would be impacted within days of the June 2025 tariff doubling. The urgency was real. The ruling itself, delivered at 9:47 a.m. Geneva time this morning, runs to 247 pages. But the core finding is brutal in its simplicity. The panel found that the United States violated GATT Articles XXI and XXI. The tariffs exceeded bound rates. They discriminated between WTO members by applying different rates to different countries in violation of the most favored nation principle. And the national security justification was legally insufficient based on 4 existing precedent decisions. Every substantive argument the U.S. legal team presented was systematically dismantled. The data shows that Canada's average effective U.S. tariff stood at just 3.1% before the disputed measures, the lowest of any major trading partner. The leap to 50% was, in the panel's words, irreconcilable with any legitimate security rationale. According to sources familiar with the proceedings, the American delegation could not reconcile the Supreme Court's own finding that IEEPA did not authorize tariffs with their simultaneous claim to the WTO that the tariffs were a legitimate exercise of national security authority. The contradiction was fatal. If your own Supreme Court says the tariffs were illegal under domestic law, how do you argue they were legal under international law? The judge's logic was airtight and merciless. The United States had effectively confessed. The ruling does not just say the tariffs are wrong. It says the United States must bring its measures into conformity with its obligations. In plain English, remove the tariffs or face authorized retaliation. But here is the brutal reality that nobody in Washington wants to discuss. The Trump administration has already signaled it will ignore WTO rulings. Sources inside the Office of the United States Trade Representative say the official position is that the WTO has no jurisdiction over American sovereignty. This is the nuclear option in international trade law. When the world's largest economy tells the world's trade referee to go to hell, the entire system begins to unravel. And Canada is not the only country watching. The European Union, Japan, South Korea, Australia, and dozens of other nations have their own WTO complaints pending against U.S. tariffs. This ruling sets a precedent. If Canada wins on steel and aluminum, every other complainant gets a roadmap to victory. The cascade is coming. Sources inside the West Wing describe the mood as one of controlled fury. The president is reportedly apoplectic, not because he fears the WTO, but because the ruling validates the narrative that his trade policy is lawless. This comes on top of the Supreme Court IEEPA humiliation 2 weeks ago, 2 consecutive legal defeats on tariffs in 14 days. The projection of strength, the entire brand of the Trump trade war, is being dismantled by judges in Washington and arbitrators in Geneva simultaneously. Trump has built his entire second-term economic identity around tariffs. When the WTO says those tariffs are illegal, and his own Supreme Court says those tariffs are unauthorized, the foundation cracks. He is not losing a legal argument. He is losing the narrative. Here is what the mainstream media is not connecting. The WTO ruling, the Supreme Court IEEPA decision, and the upcoming July 1st CUSMA review are not 3 separate crises. They are one crisis viewed from 3 angles. On July 1st, 2026, the United States, Canada, and Mexico must formally review the trade agreement and decide whether to extend it for another 16 years. If any party refuses, the agreement enters a slow death spiral of annual reviews until it expires in 2036. Sources close to the negotiations say the Trump administration was planning to use the CUSMA review as leverage to extract massive concessions from Canada on dairy, lumber, auto content rules, critical minerals, and defense spending. The tariffs were the stick. The WTO ruling just snapped the stick in half. Canada's Prime Minister Mark Carney now walks into the July negotiations with a WTO ruling in his back pocket that says America's tariffs are illegal under international law, a Supreme Court ruling that says they were unauthorized under domestic law, and polling data that shows 91% of Canadians want to reduce dependence on the United States. The leverage has completely inverted. Trump was supposed to be the strong man at the table. Instead, he is the defendant. But here is the hidden connection that nobody is talking about. The Section 122 tariffs that Trump imposed on February 24, 2026, as a replacement for the voided IEEPA tariffs, expire in 150 days. That is July 24, 2026, 23 days after the CUSMA review begins. Unless Congress votes to extend them, and sources on Capitol Hill say there is no appetite for that vote, Trump loses his tariff authority entirely. He will be sitting at the CUSMA negotiating table with no tariffs, no legal authority to impose new ones quickly, and a WTO ruling that says his previous tariffs were illegal. This is the liquidity death spiral of trade policy. Every legal avenue is closing simultaneously. Section 232 tariffs on steel, aluminum, and autos remain in place for now, but the WTO ruling creates a legal basis for Canada to seek authorized retaliation worth billions. The retaliation would hit American agricultural exports, manufactured goods, and energy products, Iowa corn, Wisconsin dairy, Texas natural gas. The political geography of retaliation is designed to inflict maximum pain on Trump's base. Let us push this to the extreme. The United States has not complied with a WTO ruling it disagreed with in years. The appellate body has been functionally dead since 2019 because the U.S. blocked the appointment of new judges. So what enforcement mechanism exists? If the United States ignores this ruling, Canada can request WTO authorization to impose retaliatory tariffs on American goods. Canada's economists have calculated the damage at approximately $11 billion annually. That means Canada could legally impose $11 billion in retaliatory tariffs on top of the retaliatory tariffs already in place on $29.8 billion worth of American steel, aluminum, and consumer goods. The combined tariff wall would be the highest between the two countries since the Smoot-Hawley era of the 1930s. We are talking about a return to Depression-era trade barriers between nations that trade $800 billion in goods and services annually. The domino effect extends far beyond North America. The European Union has its own WTO complaints pending. Japan has $28 billion in goods targeted by U.S. tariffs. South Korea, Australia, India, Brazil, all of them are in the queue. According to trade analysts, if every pending WTO complaint against the United States were to succeed, the authorized retaliation could exceed $200 billion in annual tariff exposure. American exporters, from soybean farmers to aircraft manufacturers to tech companies, would face a wall of retaliatory tariffs across every major market on Earth. This is the trade equivalent of a financial margin call. Every creditor is demanding payment at once. How does this play with the MAGA base? The hardcore supporters see this as proof the global system is rigged against America. The WTO is run by globalists. Canada is ungrateful. Expect Truth Social to erupt with demands to withdraw from the WTO entirely. But here is the fracture line. The business wing of the Republican Party, the donors, the Chamber of Commerce, the agricultural exporters, they are terrified. They see $200 billion in retaliatory exposure. They see the CUSMA review collapsing. They see supply chains that took 30 years to build being ripped apart in months. The CEO of a major Michigan auto parts manufacturer told reporters that if CUSMA fails, his company moves production to Germany, not Mexico, Germany, because at least the EU has functioning trade agreements with predictable rules. The invisible primary for 2028 is accelerating. DeSantis, Vance, Haley, they are watching and calculating. If Trump's trade war collapses under legal defeats, the populist economic message dies with it. Americans like winners, and this looks like losing. What does China think when it sees this? Beijing sees an American president who cannot win a trade case against Canada. Canada, not a superpower, a country with 40 million people. If America cannot enforce its tariffs against Ottawa, what message does that send about Taiwan, the South China Sea, the tech war? Sources in the diplomatic community say Chinese trade negotiators have already begun citing the WTO ruling in their bilateral discussions. They are telling European and Asian partners that the American tariff regime is legally and constitutionally illegitimate. The projection of American economic power relies on the perception of legal certainty. The WTO ruling has shattered that perception. The Trump administration has three options, and all of them are bad. Option one, comply with the WTO ruling, reduce tariffs, and lose the trade war narrative. Political suicide. Option two, ignore the ruling, face authorized retaliation from dozens of nations, and watch American exports get hammered. Economic suicide dressed up as sovereignty. Option three, withdraw from the WTO entirely. Sources say it is being actively discussed in the Oval Office this morning, but withdrawal does not make the tariffs legal. It removes the referee. Without the WTO, every trade relationship becomes a bilateral knife fight with no rules, no appeals, and no stability. History teaches us that cornered leaders make dangerous decisions. In 1930, the Smoot-Hawley Tariff Act triggered a global trade war that deepened the Great Depression. In 2002, George W. Bush imposed steel tariffs struck down by the WTO and complied rather than face retaliation. In 2018, Trump's first steel tariffs were found to violate WTO rules in 4 cases, and he simply ignored the rulings because the appellate body was already crippled. But this time is different. This time, the Supreme Court has also ruled against him. This time, the CUSMA review creates a hard deadline. This time, the Section 122 authority expires in months. The walls are closing in from every direction. This is not just a trade dispute. This is the stress test of the American-led economic order. For 80 years, since Bretton Woods, the United States has been the architect and the enforcer of the rules-based trading system. America wrote the rules. America built the institutions. America told every other country that the path to prosperity runs through open markets and binding agreements. And now America is the defendant. The country that created the WTO is being told by the WTO that it is breaking the law. This is what the founders of the post-war order feared. Not that the system would be attacked from outside, but that it would be hollowed out from within. We are in uncharted waters. The maps are useless. No American president has ever faced simultaneous legal defeats on trade policy from both his own Supreme Court and the International Trade Body in the same month. No administration has ever entered a mandatory trade agreement review with zero legal tariff authority and a binding international ruling declaring its policies illegal. No country has ever been the architect of the global trading system and its most flagrant violator at the same time. The precedents do not exist because this situation was supposed to be impossible. The constitutional separation of powers, the international treaty framework, the domestic statutory limits on executive authority, all of these guardrails were supposed to prevent exactly this catastrophe. They have all failed simultaneously. As we head into the evening, watch the feeds. Watch for the USTR statement on the WTO ruling. Watch for the congressional reaction, because those Section 122 tariffs need a vote by July 24th. Watch for Canada's next move, because Prime Minister Carney is reportedly convening an emergency cabinet session in Ottawa tonight to discuss accelerating the WTO retaliation timeline. Watch for the European Union, because Brussels will issue its own statement within hours. But most importantly, watch the bond market when New York opens fully tomorrow morning. Trade uncertainty is the silent killer of investment. If the bond market prices in a CUSMA collapse, the yield curve inverts further, credit spreads widen, and the recession moves from probability to certainty. For one man sitting in the Oval Office watching the legal walls close in from Geneva and Washington simultaneously, this is not a policy setback. This is an existential threat to the only legacy he cares about: the image of the winner, the deal maker, the man who could bend the global economy to his will through sheer force. The gavel in Geneva just told the world that force is not enough. The law still matters, and the law just ruled against the United States of America. Let us get technical about what authorized WTO retaliation actually looks like, because this is the mechanism that could dismantle billions in American export revenue within months. Under Article 22 of the WTO Dispute Settlement Understanding, when a member fails to comply with a panel ruling, the prevailing party can request authorization to suspend concessions. Canada gets permission to impose retaliatory tariffs. But the retaliation does not have to target the same sector. This is called cross-retaliation. Canada could impose tariffs on American agricultural products, hitting Iowa, Nebraska, and Kansas. It could target pharmaceutical exports, hitting New Jersey and Connecticut. It could restrict American financial services access, hitting Wall Street. The target list is chosen for political leverage, not economic symmetry. Every senator, every congressman, every governor who represents an export-dependent state will feel the pressure. The phone calls to the White House will be relentless. Remove the tariffs or we lose our seats. That is the mechanism. That is how a WTO ruling in Geneva translates into political pressure in Washington. And for a president already reeling from the Supreme Court IEEPA defeat, already facing the CUSMA deadline, already watching his tariff authority expire, the authorized retaliation is the final nail. The trade war is not being won. It is being lost on every front simultaneously. Subscribe. Stay tuned. The rulebook of the global economy is being rewritten this week, and whoever controls the narrative controls the outcome. The gavel has fallen. The ruling is in. And the United States, for the first time in the history of the institution it created, has no legal response. History is watching.